So I think let's start. Welcome to our webinar on US immigration pathways for people with extraordinary ability. I am Mian Tariq Hassan. I am a founding partner of Access Law Chambers based in Pakistan and a founding member of Absolute Legal Works based in St. Louis. I am joined with Mr. Mark Popiel and Mr. Jitesh Malik, who are managing partners of Malik and Popiel. So today we'll be covering three specific categories, which are the EB1-A category, then EB2 category, and then the O1 visa. So without wasting any further time, I invite Mr. Mark Popiel to give an introduction about himself and then jump into the details.
Hello, everyone. My name is Mark Popiel, managing partner of Malik and Popiel. My partner, Jitesh Malik, is also joining us. Our firm is predominantly, I would say, 95% employment-based firm, where we represent employers and professionals and guiding them through from the temporary process to enter the U.S. and be able to gain temporary employment in the U.S. through permanent residency, processing, and pathways, as we're going to discuss today. They're actually, just as a caveat, there are many other pathways to get permanent residency, but this is just a slight sliver, a little sliver of what is available. We also counsel clients to obtain U.S. citizenship. And the normal progression that folks follow is usually they obtain temporary work authorization. They thereafter move into permanent residency processing, which is the green card. And then once they've been in the U.S. for a certain period of time, they're able to then transition themselves to obtain U.S. citizenship. And we walk them through that entire process. The other, I would say 5% or 5-10% of that, we counsel individuals on family-based immigration because there are other pathways, and one of them may be being sponsored by a family member, and that may be quicker. Our goal and how we structure, what we do for our clients, we look at their short-term and long-term objectives, and we look at what pathway may be available that is the least costly and the quickest, because obviously people want to process through, and it is a bureaucratic process. So today we're going to do a discussion. My partner actually in New York City, I'm in the Buffalo office, Buffalo, New York, and he's in New York City office. He also counsels clients in similar aspects, and we do a lot of business immigration as well. So we're well versed into this. And then as you have questions, we open it up that you just, let Tariq know, and then we will address any questions that are available. We'll also leave some time at the end of this process to, answer any additional questions you may have. So without further delay, if you give me 1 second, I'm going to share my screen. Does everybody see that? We good?
Yeah, we're good.
Okay. So I think as we always sort of go through, the presentations that we have, I think it's important to understand sort of what we're going to cover. So first and foremost, we're going to discuss the framework that we are dealing with when we deal with U.S. citizenship and immigration services and so forth, and the government itself, a little bit of terminology. We're going to focus first on the O1 because it's the temporary employment structure through people that people actually move through and process to be able to come in to the U.S. quicker. Then we're going to look at long-term, and as has been discussed, the big aspects of this discussion, or the primary aspects, are the EB1-A and then the national interest waiver. These have gained traction because for the most part in the U.S. system, you require to have a U.S. employer. When it comes down to permanent residency with EB1-A, as we'll discuss on the NIW, those are two areas where you actually don't need a U.S. employer. You can actually self-sponsor yourself. So, couple, initial things to discuss. What's the U.S. structure? Most commonly, the first one we start with is the U.S. Department of Labor. This agency comes into play because they control, in essence, wages that are being offered to foreign nationals And in the most probably important two areas, which we obviously are not discussing fully today, we can still answer questions anybody may have, are those who are processing through a classification called H1B, and perm, the Department of Labor sets what we call prevailing wages. They also are involved where an employer has to test the labor market to see if there are any U.S. workers available. The Department of Labor is fully immersed in that process because all the paperwork is sent to the Department of Labor. For today's discussion, most of the filings that we are dealing with do not involve Department of Labor. So in essence, we're being exempt. We go bypass that process. So we are solely dealing with the U.S. Citizenship and Immigration Services. They're called USCIS. They're actually the old INS. This agency looks at obtaining or issuing paperwork for a person to be able to work in the U.S. So this is where the work authorization comes in. They also work in conjunction with the U.S. Department of State. Department of State, if you've ever obtained a U.S. visa, that's the agency that actually processes visas. They also are involved when you look at the permanent residency process. They're also instrumental in allocating green cards. They actually look at how many green cards are being issued each year. And when we're going to conclude our discussion today, looking at backlogs and so forth, there are, from the employment-based perspective, there are 140,000 green cards that are allocated for each year. This includes, out of the 140,000, this includes the primary filer and any of his or her family members. And for certain countries, those numbers are used up fairly quickly, in particular India and China. Other individuals, for instance, who were born in Pakistan, they actually fall into a classification called all chargeability. It's actually a much quicker pathway because there are less people processing through that pathway. So we'll deal with U.S. Citizenship and Immigration Services as well as Department of State. Jitesh.
Yeah, so let's first get started with the O1, which is a temporary non-immigrant employment visa. You do require a U.S. employer. So for this category, it's a temporary classification. You can come here on a non-immigrant visa. You can stay here up to 3 years for the first time, and with 1 year extensions thereafter. But it does require a U.S. employer. So whatever your field of expertise is, you would require a U.S. employer to sponsor you for the visa. To qualify a foreign national of extraordinary ability, it could be any field: science, education, business, or athletics. As long as you have expertise there, must demonstrate sustained national or international acclaim. So sustained means over the last few years you have been recognized in the field as a leader, and you have national or international. So if you're in athletics, you have national level championships or international championship, or if you're a scientist, you have awards from your own country and from countries abroad. And recognition for achievements in the field of expertise. We have to demonstrate.
And we will show everyone what that is.
Yeah, unless Nobel Prize winner, which clearly justifies that you are a person of extraordinary ability. We'll go through a list of 3 out of 10. Mark, next slide, please.
Yeah, the other point to mention, the sustained. So what happens is, there are many cases that are filed with the government, and they go before different officers. This is a very discretionary process. So one officer may be more open-minded than another one. But the sustained national and international acclaim is important to understand that, for instance, if you have somebody who is just recently joining the field, they just maybe obtain their PhD degree and they're expanding sort of in this field and so forth. The challenge may or may not be dependent on the officer is whether it's been sustained. If you've just only done a few things in the last year or two, the government could very likely say, well, hang on a second, if you deem yourself to be of extraordinary caliber, how have you been actually performing, doing these things? Have you, building your professional portfolio? So this usually requires, this filing is usually for individuals who have actually done it for a number of years. The way to look at it is probably if you deem yourself to be in the top 5-10% of your peers in the field, it's probably a an area you want to explore, because as Jitesh has mentioned, the way the law is written here, a person is eligible for an O1 if, for instance, they received a major international or national award. And so that would be a Nobel Prize.
Yeah.
All right, Jitesh, there you go.
So unless you have a Nobel Prize, then then you don't have to look at any other, documentation. But if you don't have a Nobel Prize, then you have to accomplish 3 out of the forms of documentation. Now we have to justify and establish that you are in receipt of a national or international award or prizes in your field of endeavor. So whether it's science or business or athletics. And then second is membership in associations in the field for which classification is sought. It's not, I mean, as a professional, you could be a member of 1,000 organizations. That doesn't mean anything. That's good for you, but not for the standard when it comes to O1. Okay, we have to establish that, mostly it's an invited
Right.
member.
Normally in this area, when we qualify it, we actually have to obtain evidence or paperwork of that organization to look at their selection criteria. So for instance, there are some professional organizations out there that admit people based on their achievements, based on them being recognized as of extraordinary or outstanding caliber. And so then our focus would be, as Jitesh said, that these organizations are not virtually just admitting people based on their academic achievements. Another way to look at it is if you obtain a PhD, you could be a member of 1,000 organizations by virtue of holding a PhD. If the standard was that would count, then everybody with a PhD would meet that requirement. So we have to look at, in essence, are these organizations very selective in who they admit, and what's their sort of standard? And in all of these findings, the key in successful cases to back up and support what you're claiming. Simply merely saying it to the government, they're never going to accept it.
I mean, the selection process is of very high standard here. I mean, we can't just go with a PhD. Of course, it takes a lot of hard work and effort to get a PhD, but that's not the standard when the O1 or EB1 or NIW is looked at. So the third is, and this is more for scientists, people in the field of science, published material in professional or major journals. Unless, of course, you could establish.
Or recently, arts, for instance, if you're doing exhibits and there are written things about you, that may come into play.
Correct. So
in the sciences also, we've used citations. I can tell you the government normally pushes back on citation records, saying, well, citations in the science, right? So if you do research and development and you have some findings and you published it and somebody is citing your work and you have citations, the government says, well, that's not necessarily what they're looking for, because they want published material to be written about your work and not merely citing to your work. There is case law out there that disputes that position, and normally we push back with the government, because if a person has extensive citations, and normally over 100 or more citations, courts have come back and saying that this is indicative of a person's achievement of a certain stature. And so we kind of push back to the government saying, well, if you have more than 100 citations, obviously others are using this individual's work in furtherance of theirs, and that should be given some recognition and weight when it comes to establishing whether a person has met this standard.
And the published material also goes to establish that this is cutting edge contribution you're making to the field. I mean, this is a contribution of major significance in the field of endeavor. So
exactly.
And the balance 6, 7 are again, it depends on the field, but in the sciences, if you are evidence of participation on a panel as a judge, when you are reviewing the work of others, that's very important. They look at that. That's one of the standards. Evidence of original scientific scholarly contribution in the field. That's very important. We have to establish it. Authorship of scholarly articles in the field. I mean, that's in professional journals. That's the one standard. Display of others' person work in artistic. This is for the people in the art field. Okay, this is not people in the science field. Evidence that the person has been employed in a critical or essential capacity for organization. Now, critical role, if you're working for a company, whether international company, and you possess a very critical role there, or an essential capacity, we need to establish there are a lot of documentation required. I mean, these may seem very easy to establish, but these petitions are 1,000 pages plus when we submit them. There's a lot of documentation which needs to go through. Then the next is evidence that the person has commanded a high salary. Sometimes in the business world, not in the science field, but business or athletics, it's easy to establish high salary as a standard. Evidence of commercial success by box office. So this is more people from the movie industry or TV industry, if we say that. Yeah. So
Right.
those are the 10 standards. Out of them, you need to meet at least 3, and at least 3 doesn't.
Just to file.
Yeah, just to file. And if you're just meeting the mere 3, it doesn't mean that your case is going to get approved. It's just that they will take your case, they will review it if you meet at least 3. But as Mark said, and as we pointed out, there's a lot of documentation involved in these filing, and you really have to establish that you are doing cutting edge contribution to the field, and you have to demonstrate all these authorship of scholarly articles, citations, awards, judge of others. All those things are very, very, very important.
Right. In essence, the government actually does a 2-step analysis here. So the first step, really, they look at, has the person met the threshold for the case to be accepted? So in another way to put it, has the person met at least 3 out of the 10 criteria? Then they look at, well, if they have, are these, have they met it by strong criteria, or, what have they done? The second part of this process, assuming that the government has said, okay, they've met the parameters of what the regulations say, is then to do a balancing test. And they look at, has this person, based on what they've achieved, have they gone above and beyond what others in their field normally do? Because as an example, for instance, if you have a scientist, the scientist typically will do research, they will publish articles and so forth, they'll present, do all these other things. So being a judge of others, they may sit as a peer review journal on a journal and so forth as a reviewer. So then the government will say, well, isn't it common then for scientists to do all those things? So how have you distinguished yourself above others? And so it's the 2-part sort of analysis that they actually, are involved in. So it's important to distinguish that person. And the key in a case is because this is a very discretionary process, is to then elevate the person to, in the paperwork that's submitted, to say this person has done this and this and this. They're a leader in their field, and they are recognized. And Jitesh pointed out number 5. I would say they're all important, but out of all of these, one of the most important is number 5: evidence of original scientific, scholarly, or business related contributions of major significance in the field. Why I look at that one is because normally to meet this prong, you have to get expert letters, both from international, renowned experts in the field, to articulate how your work has actually been viewed as of major significance in the field. And so it's very important to get expert letters with examples and so forth that substantiate the claims. And then what we do is we take sections of those letters and put them in the petition to highlight what the person has done and distinguish them from others in the field, that this person has gone above and beyond. So this section for O1A, you'll actually see in a minute when we deal with permanent residency through the EB1-A, the standard is actually identical. Very similar. The government does look much more closely on the green card filing versus this one. So it's important. And we actually go into greater detail on some of these for you as well.
But the standard is pretty much the same.
So most of the time, if somebody passes or qualifies as a O1, they are on the path to explore doing an EB1-A.
Yeah.
So, and you'll see why in a minute. So, and the other now, as far as, so that's the O1, you can obtain temporary work authorization. It is quicker. The one question you may ask yourself, well, why am I going to go through the O1 and not permanent residency? Length of time, because it does take longer to prepare a case, but most importantly, you can process it quicker with the government. permanent residency will not process as quickly as as a temporary filing. And so most of the time individuals explore the option of coming to the US first, and then once they're here, then they explore doing permanent residency.
And if you, just a follow-up question, if somebody comes on an O1, their family can join them and get the visa, O2 visas for the dependents, the spouse and the kids. No parents allowed, the spouse and kids can also join the primary person coming on the O1.
So what's generally the processing time, average processing time? If you were to guess, what range would you?
Normally, normal processing time for an O1, because it's filed with the USCIS, it takes around 6 to 8 months. That's just very normal. But there are ways to expedite it by paying the government premium processing fee, expedited fee. And then in that case, they can adjudicate it within 15-20 days. So normal processing time, once it's approved by the immigration service here, then the person will have to apply for a non-immigrant visa at the US consulate in Karachi or wherever the person lives, to the nearest US consulate. And then that could take a little bit of time, sometimes 4 weeks, 6 weeks. So I would say if the case is done expedited processing, you are looking at a time frame of maybe 3 to 4 months at maximum. A person will be here. But if it's
versus permanent residency, you're looking at
for permanent residency, there's a long wait,
right.
3 to 4 years. So we'll talk about it in the later slide also. We'll show you a visa bulletin. There are backlogs. So for O1 or any non-immigrant visa, you could be here in 4 to 6 months. But for permanent residence or green card, you're looking at 3 to 4 years of waiting time. And
so, employment is required. Employment offer is required, and you need to show that.
Definitely. So
yes and no. For EB1-A and national interest waiver, normally you don't have to provide an offer of employment, but it is wise to put it in because everybody that processes for permanent residency has to pass what is called a public charge. And what that is the government looks at their case and says, if we were to grant permanent residency to you, will you be dependent on the government for support? And so if you can get an offer letter and put that in, that actually goes a long way to addressing it. Do you under regulations require to have that letter? No, but because this is a human process with discretion and questions that these officers ask, having that letter does help your case.
Yeah. Because otherwise, how do you establish that you can take care of yourself? You're not going to become a public charge. So
right.
It's okay to, it's actually better to have a letter of sponsorship.
Yeah, and this is the national interest waiver standard. And if you look at, and Jitesh is going to kind of go through some of these elements, number 2 kind of seeks to address the public charge because you have to show that you're well positioned to advance whatever you're intending to do. So normally getting an offer letter, that kind of, you want to put it in to establish that prong. That once you are given a permanent residency, you're able to continue with what you're doing. So Jitesh, I'll hand that off to you.
Yeah, national interest waiver. Its shorter form is NIW, national interest waiver. What does that even mean? So that the proposed, foreign national proposed endeavor, whether it's science or business, has both substantial merit and national importance. A wide range of fields of endeavor may qualify, including business, entrepreneurship, science, technology, culture, health, and education. So it has to be in the national interest of the US government, okay? National importance. We really have to justify what the person does, of course, and then cutting edge contribution to the field and how this would benefit the US national interest.
Right. So you look at, for instance, what the person is doing or is intending to do, and then you have to, in essence, connect it up. Are there government agencies that are in essence, pushing or have outlined, areas that are of national importance? Actually, the White House normally has published a paper that goes into detail as to critical areas of infrastructure or areas that are vital to the success of the U.S. And so, usually we look at this to see if a person fits.
Yeah. The second prong, which they definitely we need to establish, is that the foreign national is well positioned to advance the proposed endeavor. So if you've been, and if you've been doing research on a specific scientific, field, then are you going to continue that research or that endeavor? That's very important. You can't come here and change the field. So USCIS will look at your education, skills, knowledge, record of success, all those things, a model or a plan for future activities. So you're going to say, okay, I've been doing cancer research. This is what I've achieved so far, and I'm going to continue my endeavor. So that's very important to establish that. And how do you establish that proposed continued endeavor? Is if you're a cancer researcher and you've been writing articles, then are you continuing? If your article is 5 years old, then how do you establish that you're continuing your endeavor? So it's very important that the articles, all those things are very current, up to date. It's not like they were done in the past life, 5 years back, 6 years back.
Whenever we look at a person's resume, that's one area we look at. And sometimes, and we obviously are involved in this area very significantly. We see a lot of resumes. So you have, for instance, somebody who's obtained the professional qualifications, education, and so forth. They've published and presented and done all these things. And all of a sudden, all those things, when you look at them, they haven't actually done anything substantial in the last 8 or 10 years. The government's going to frown upon that because they're going to say, well, you've done all, you've published, you've presented, you've been active, and then all of a sudden you've stopped. So they're going to look at it in a negative way. Or you're going to have somebody who just recently finished their, education and is starting off, and they're maybe just at the beginning of their professional aspirations and what they're doing. And so the government could push back saying you're just sort of starting off. It's not, it's not really the time yet. You haven't established all the criteria. So it's a hit and miss. I mean, you could have somebody who just recently graduated and have developed something cutting edge. So I'm not saying, recent graduates may not qualify, because they may. You just have to look at whatever the area you're in and what you've done, and can you establish that what you're doing is in the national interest. So if you're doing, for instance, cybersecurity and all those things along those lines, you may be able to make a claim. You just have to look at, are there unique things that you've done?
Yeah, I mean, common examples are cybersecurity. In energy sector, there are tons.
Right.
So
there's, it's case by case, and you have to look at, are the things that you're doing critical to the U.S., and can we then connect it up to a government policy or agency policy that they're saying, we need this, for instance, development of infrastructure in the U.S. or other areas, and that's we then use that as a basis.
So NIW, National Interest Waiver, is still a green card category under EB2, and EB2 has backlogs. Normally, EB2 requires a perm labor certification that you have to go through the Department of Labor, file the
and an employer,
and then you test the labor market and all those things. So in that process, 1.5 years to 2 years is wasted. Okay, that's the whole time, almost around 2 years is gone. But this national interest waiver, what it does is it waives the filing of the labor certification, the need for the filing of the labor certification. So you essentially save 2 years of the whole processing time. But they will only waive it if you are considered as an NIW, as a national interest, or you are making some contributions to the U.S. in the field, and it's in the national interest that your services are required urgently to warrant foregoing of the labor certification process. They will waive the labor certification process only if you are qualified as an NIW. Then they'll say, you know what? Yeah, we agree. What you do is in the national interest, and we will not ask you to go and file a labor certification. So that's where you save almost 2 years of processing time. But there are still backlogs. It's not like you come in tomorrow morning. You still have to stand in line because there are other people in front of you. So everybody stands in line, and when the visa dates become.
Yeah. And we'll show the bulletin so everybody sees, because it's important to kind of view it and then you know, visualize where things stand. I think there's a question on says, hi, I'm a physiotherapist and like to know that if I'm eligible for an EB2 NIW, as I don't have publications, but I have 6 years of experience and official license from UK.
Also
I
give
mean,
an IEL test, the English language test.
go ahead, Jitesh.
Go ahead. IEL test. That's the English language test, I was saying.
Right. I mean, I guess the official license from UK, you know, we're dealing with the US system. So when it comes to licensing, it's definitely something you'd have to explore to look at what it would take to get a US license. If physiotherapist is similar to a physical therapist, there is a national interest waiver, but the process is a little bit different for physical therapists. We normally do them. You first have to, and this would require an employer, and you have to do a wage determination, which is filed with the Department of Labor. And then there's an internal posting, and you actually are exempt. Physical therapists, for instance, and nurses are deemed to be Schedule 8 classifications, which means that there's deemed already a shortage in this area. And so physical therapists don't have to go through the perm labor certification. You know, there is a process that's slightly different, but you could pursue it. But you would need a US employer.
NIW filing at all, because you know it's a regular EB2 filing anyways.
Right.
So
And it would be EB2.
NIW, as long as you have the licensing in the US, you could straight away go to the EB2 filing, and
But
as
what
long as you have a sponsor, as long as you have a sponsor now.
that EB2, I mean, the only thing I would pause is EB2 would be dependent on a person having a master's degree. If you don't have it, but you're still a physical therapist with a bachelor's, it would be an EB3, but the process is very similar.
No, but we could get it classified with bachelor's and 5 years of experience.
Could, if we have 5 years, here we have 6, so yes.
He has 6, so he may qualify. I mean,
Mhm.
you know, feel free to share your resume with us, and in the meantime, start looking at the licensing on the US side of a physiotherapist.
All right. Now the EB1-A process. This is permanent residency. You've seen, as we've said, similar to the O1 standard. You have to qualify as an EB1 extraordinary ability, and all the similar things that we've pointed out in the O1 are here. The government, in essence, isn't reinventing the wheel. They're looking at has this person achieved all these things? Same thing. They start off receipt of international awards such as Nobel Prize and so forth, or if you haven't met that, at least 3 of the following, and then you look at these ones. We're going to actually, in this section, we're going to do it a little bit different. We're going to go through sort of one by one, and you can kind of see kind of things that what you may need. So for instance, for outstanding achievements in the academic field, awards, right? You have to put in award certificates, letters, email messages, letters awarding competitive awards, grants, fellowships, for instance. When we do those grants and fellowships, it would be important to provide the government with how competitive these were. So you have to then, you know, look at, was it highly competitive? Was the award deemed to be outstanding by maybe expert letters and so forth? So the significance of the award and or the grant of fellowships we have to look at. And same thing with the organizations granting it. You want to provide a lot of background. Jitesh mentioned in these filings, there's extensive documentation. That is very true. I mean, these filings, you know, are 700, 800, 900 pages in length half the time, because you're substantiating all the positions. All right, Jitesh, I'll leave you with the next one.
Yeah, membership in associations in the academic field which require outstanding achievement. We've already discussed this. Just by having PhD, you could be a member of, you know, 100 of organizations. Doesn't mean anything for the USCIS. You really need to establish that the associations are at a national or international level, and then it's an invited membership also, for which you really need to establish cutting edge contribution to the field. And it's so we really have to establish through documents explaining the criteria of the selection and general information about the scope and objectives of the association. So A lot of paperwork goes into that too. Yeah.
Authorship of scholarly publication, you want to actually provide a copy of the publication itself. And it should be a professional journal, for instance. You want to kind of expand on that as to where it appears. Most of the time, you want to put in some information relating to the journal, their stature in the discipline in that field and so forth. So all those things you want to put in. A lot of times the journals will actually have a selection criteria. So do they publish literally anything that comes through their door, or are they highly competitive to publish? So you want to establish that because of what you're presenting or what you've written about, it was actually circulated to a wide audience. So that's a very important one.
Yeah, and then evidence of presentation or talks. Again, at international conferences, so you really have to, demonstrate through abstracts or invitational letters or email, or if you're, of course, documents explaining the criteria for the selection, again, a conference schedule, information regarding the scope or objectives of the organization, committee information, all those things are necessary so that you can establish that, okay, you presented at 10 international talks and conferences, and here is the documentation of each of the talk. Definitely listed on your resume. Start listing it on your resume. Resume has to detail all these things. It's very important that you list all of these and start collecting all the documents pertaining to each of the specific prong.
Next one is published material about the individual's work in the academic field. This takes sort of a form of a couple different things. One is if you have a journal or newspaper article that cites to your work and explains the impact that you've made, and keeping in mind the standard is of major significance in the field, that's something you would want to provide to the government. Sometimes there are published reviews about what you're developing and so forth. Footnote comments, you would focus on those things. So at the end of it, and we actually, as I've said on the other for the O1, we use citation records sometimes if a person has an extensive citation record. It's very helpful. The key in this process, and we'll go, Jitesh will do the judge of others in a minute, but the key in this process is not to try and throw every single thing into the EB1 bucket, as I will call it. If you have 3 out of 10 criteria, you may want to kind of look at what are the strongest ones. Simply putting every single thing dilutes sometimes a strong case. And so we don't necessarily suggest doing that as well. So
next prong is judge of others. So
just a quick question, like what in your experience is a good number of published materials, citations for a successful application? So
I mean, when you look at, that's a very good question. So for instance, how many articles does one need to have? I would say probably 10 or more published articles, probably 15 or so. I mean, we get all kinds. So we have individuals who have published 100 times. They have 100 publications. Some are even more than that. Do you need that many? Not at all. I mean, if you've presented and published and you're between those two, you have 15 to 20, I think you're in a good spot. If you've been cited significantly, ideally 100 or more, that's definitely working in the right direction. If you've served as a judge of others by being a peer reviewer on a host of, international journals, that's very helpful. And if you have patents, that shows obviously original contributions by having patents. And then, associations, I would tell you over the years, in practicing for quite a long time, associations is one of the prongs that's least used, because a lot of times associations are based on just simply achieving a certain level of education attainment, and that's not going to be very helpful. But there are people, like there's an organization, Sigma Psi, which uses a very highly selection of candidates. Academy of Science is another one where they actually base it on high achievement in the field. So sometimes you do work, you use it. But you kind of get a sense. as to whether this is a time for a person to move forward or not. And many times, if the answer is, we don't feel that, and we don't actually, I'll tell you, we don't file every case that people want filed, because if we don't feel that it has a chance of success, we're the first ones to raise our hand and tell the individual, you may want to wait. And a lot of times our discussion is early on, when we see a case that is moving in the right direction but isn't there yet, we kind of put together a plan in the next 6 months or next year. This is what you should be doing, strengthen your case. To actually just simply filing it doesn't help the person either. Right. So, but that's a very good question. Like, how much is enough? Like, if a person has strong experience letters, because you have independent expert letters, for instance, that go into detail with examples to show what they've done are original contributions of major significance. If the letters are strong and supported by, actual evidence, then I think that strengthens the case overall. Simply saying, oh, the person's a great role model, they've been very hardworking, and we feel that this person's going to really contribute to the US, that letter is useless. What you want is a letter that goes into detail saying this person is now an expert in their field, over their course of their, career thus far, they've identified this or developed this or that, and this is how it's impacted, this is how it's original, and this is how it's of major significance, and this, whatever they've done, is applicable to the public sector, and this is how it's better, for the betterment of the public. And so those are letters you want. If you look at, we kind of ironically enough left there's original scientific, research contributions, and how many do you need? What do you need? So for instance, copies of patents. If you're in the arts, photographs, art exhibits, all those things. Normally, and the problem in explaining this kind of area is, well, how many letters do you need? We put 7 to 10 as a wish list. Do we have all cases that have 7 to 10? Not at all. I think if you have 5 letters, I think we're still fine. Well, you definitely want to have letters that substantiate what the person's doing. It's also important to know that if you're, for instance, providing 7 letters, that these letters don't be the same letter just signed by 7 different people, because that has almost very little value as well. So the key here is, if you're going to have individuals write letters on your behalf, or most commonly you're writing it on there and then they're making changes and signing it, you focus on different aspects of what you've done in the field, and you have each letter sort of focus on that aspect. So this is not a same letter that's just reproduced and signed by, a whole host of individuals. It really has very little meaning to the government, and they're not going to really put much weight on it.
The other thing is, these letters also should not be from the same office or same, university or something, because
right.
They don't play, more focus on that. It's better that it's from outside of your circle, people who are not in your same office or same college, or you went to school with the same person, or you went to the PhD program with the same person, so.
Plus, a lot of times, it's helpful for these letters to be written from those individuals who actually are using your technologies or the skills that you develop, where they can say, you know what, I've actually been following this person, and now we are using whatever they discovered in our laboratory. That's a very strong letter, because it shows your impact on the field, right? And so those are very good letters. We normally, as the bottom of this slide alludes to, getting a resume from the person who's going to write the letter is very important. The letter shouldn't be very short, in a sense, a paragraph or two, unless the person is a Nobel Prize winner writing a letter of support. I'll tell you, a few sentences from that person should work. So stature of the person who's writing is very important. And as Jitesh has mentioned, like, if it's being done through an employer, that you have an employer that's willing to bring you on board, even though you can do this as self-sponsored, letters by an employer that's seeking to hire you in the US are usually viewed as self-serving. The employers will write virtually anything to get you. So, but usually you can have one letter like that.
Yeah.
Even though we don't discuss it here today, because we obviously have limited time, in the EB1 process, this is EB1-A. There's a process called EB1-B, outstanding professors and researchers. That's another area. Now, those filing require definitely an employer. In outstanding professors, obviously it's usually an academic institution in the US that would have to sponsor you. However, when you look at EB1-B for outstanding researchers, we represent many organizations that have done EB1-Bs for outstanding researchers, for instance, in the pharmaceutical world. So you may have a company, there's a pharmaceutical research and development company that has at least 3 full-time researchers. They in the private sector can also file an EB1-B for a person. When you look at the standards are very similar, but the EB1-B for outstanding researchers is actually a lower standard. You have to establish 2 out of the 6 to file rather than 3 out of 10. And so a person may actually be more successful if they have for instance, a pharmaceutical laboratory that's willing to bring them on board. The outstanding researcher path may be one to actually explore. So the takeaway from our discussion today is that while we cover a lot of different subject matter here, there may be other pathways that may be available to you. So you don't want to just discount saying, well, I didn't hear it today, then I don't have a path going forward. That's not necessarily true. It's a case specific, and we need to understand the circumstances in your background and what you actually are bringing to the table. And then we can kind of filter through to see if there's a way to actually, structure a pathway that's more, appropriate to you.
Any questions, feel free to email to Tariq, and and we can all discuss it.
How many cases EB2 NIW processed and approved by your firm? Frankly, we've done so many, we don't keep count. I can tell you on a regular weekly basis, we get many increase, and many of these increase, we tell people that they may want to wait because they haven't elevated themselves yet to that point. But we do a lot of EB, like I said, when I started our discussion today, EB2 NIW, we do those. We do EB1s, extraordinary ability, outstanding professor, researcher. We do a lot of multinational manager filing cases and so forth. Perm processing, which is labor certification. We do many through the year, in a year. But we have a very high level of approval. Very rarely do we run into an issue. And even then, if we do, we actually try and find a way around it. It is a discretionary process, and we're dealing with different officers and so forth. So the key for us is not to simply just file a case for the sake of filing it, because it doesn't help you, it doesn't help us, because we have to then try and address it with the government, and obviously our goal is to achieve an approval. So we take this very seriously, and we look at and steer people in the right direction, or at least that we feel is the right path.
Like Mark said, we don't just simply blindly file cases.
Right.
We review them thoroughly, and there's always 2 or 3 attorneys working on each case. It's not like we just get the information from you and we go ahead and file it. No, so review process is very strong in our firm, and then preparation process is also very strong because 2 or 3 people are reviewing it and working on it, all those things. So, most of the time we refuse cases where we feel that it's not gonna have a positive outcome, and sometimes it's 50-50. That time we discuss it with the clients.
And we tell the clients what we feel as far as I myself don't like percentages, because percentages are that, right? If we say, well, you have a 80% chance of approval, well, there's still that 20% of denial, right? So you could be denied. So normally I try and sort of frame it, do I feel it's a strong case or sort of in the middle or on the weak side? Because it's, but there are cases which are, in all our years of practice, I mean, we have a good sense what has worked, what option is best suited for the person. And that's kind of how we approach it. But yeah, if we don't feel that this case has great success, we'll be the first ones to tell people. And we're not trying to insult anybody. We're just giving them our honest opinion.
Yeah. Okay. Let's go to the next slide.
So priority dates. We alluded through today's discussion as we wrap up sort of our presentation and discussion today, the backlogs and all these things. So everything is based on priority dates. What it is priority date, the way to look at it is when you file permanent residency, you, in essence, the date the government accepts your case is the date where you have a priority date. That's a date you get yourself in line for permanent residency. Green cards, as I mentioned, there are 140,000 green cards issued each year. It's based on country of birth also. So there's the same amount of green cards are issued to each country. Some countries have more demand than others, and that's where you have backlogs. The priority date itself is the ticket of where you stand in that line. And so, and I'll actually show you there's a September visa bulletin. And this actually alludes to where the government is in that whole processing of permanent residency cases. If you look at to the left side, it says employment based. So you have first, second, third, others, religious workers, and so forth. So EB1's extraordinary ability, outstanding professor researchers, for instance, are always in the first. Whenever you see the letter C, that means it's current. And then you have 4 countries, China, India, Mexico, and Philippines. Those are countries of birth. Everybody else that's not born in those countries are now in all chargeability areas. So if you're born in Pakistan and you want to pursue, for instance, an extraordinary ability petition or an outstanding professor researcher case, if you scroll down to the all chargeability in first, you have this C, which means it's current. The processing time will be significantly different than, for instance, if you were from, let's say, China or India, because the backlog means you may be able to start the green card process. And think of it this way, there are stages to the green card process. First is filing what is called an I-140 petition as an outstanding professor researcher, or as an outstanding extraordinary ability individual, or a national interest waiver, or whatever the case may be. When you file that, that gets you your priority date. And then you have to kind of find, where are you in this chart? Right, Jitesh?
Right. So if you do like national interest waiver, NIW filing, it falls under the category of EB2, the second, which is master's degree. And they are processing right now, March 25th of 2023 for Pakistan and other 196 countries, except these 4 countries, China, India. They have different dates. So there's a huge backlog in those 4 countries. Whereas on the first slide, it says March 25th, 2023. So again, like we discussed it does take a couple of years, so you could file the NIW filing today, but it could get approved in 7-8 months, 10 months, but then you have to wait in line. And once your date is current, then only the government will give you the option to go to step 2, which is, okay, preparing for the visa appointment and all those things.
Right. So the way to look at it is different pathways have either 2 or 3 steps to it. This visa bulletin does not preclude you from filing anything. And it's actually important you file it sooner than later. So when you file the first set of paperwork, the immigrant petition, you have that priority date. That gets you in line. Once it's processed, the next step, whether it's 2 or 3 steps where you have to do, for you to get a green card, you have to, normally if you're going to go and do this from outside the US, you would consular process for the immigrant visa, the green card visa. The green card visas are actually what are backlogged. So the key is, for instance, if we filed your NIW petition today, you would be given a priority date of August 29th of 2024. That means now you'd have to wait and look at this chart on a monthly basis to see whether the government has gotten to now processing August 29th of 2024 before you can file the last step of your green card process. And that's why it's important. So for instance, if you said, well, I'm waiting, I'm not going to file anything, I'm going to look at this chart, I'm going to wait until that chart shows me August 29th of 2024. If you've never filed anything, you never have a priority date. You never even have that ticket to be in line for permanent residency. You could wait 20 years and that chart's going to be of no use because you're not even in line. So getting in line is actually key.
So the first category is for the extraordinary people we already discussed, extraordinary EB1 filings, ability filings. The second category is for people with master's degree or bachelor's with 5 years of experience. The third option is the bachelor's degree. So people who don't have qualifications for the EB1 or the EB2 should not get discouraged. They could still go for a green card filing through their US employer. It does require a US employer to file for their green card, and they could fall on the third category, which is not too bad compared to other countries.
If you look at India.
Yeah, there's a 12-year waiting line there. But even if you don't have the option to file EB1 or EB2, and if you have a US employer who's willing to hire you for a skilled or an unskilled position. Now, here's the catch. It could be skilled or unskilled. You would still fall under the EB3 category, and you could still get your green card in, I would say, 4 years or so, because right now they are doing December of 2020. So there's a 4.5 year waiting line by the time the process is done. But it's doable. It's still doable. So don't get discouraged for yourself or your family members. If you have a US employer willing to sponsor you for a green card, go forward with it. 3-4 years is nothing as compared to
the other thing to keep in mind, and this is very important, this chart isn't counted on a calendar basis. What that means is this chart only reflects where the government is in the process. So for instance, each month they issue a bulletin. There are times where the bulletin will actually move forward in a month's time. It could move forward by 6 months or a year. It could go backwards. So it's like a swinging pendulum.
It depends on the availability of the visas and the demand.
Right. And the other takeaway here is because this is a September bulletin, this is the last fiscal month for the government cycle. So they've already used up most of the green cards already, because the government operates on October 1st calendar year. So October 1st is the beginning of government's new year.
I'll just wrap
For
up
instance,
categories on the visa bulletin. It's the 4th category. It's for religious workers. So if you have a mosque here and you want to send people from the mosque in Pakistan to the mosque in the US, that's the category for them, religious workers. Okay. The 5th category is for green card through investment. So investment amounts are 800,000 for targeted employment areas where there's high unemployment, or the $1,050,000 for regular areas. So you could obtain a green card through investment also of $1 million plus, as long as you have a genuine business going on here, enterprise, and you're creating jobs in the US. So that's the 4th and the 5th category for you. Just so everybody understands,
And sort of in a nutshell, that's the US permanent residency process when you look at O1, EB1-A, and national interest waiver. And there are other avenues, and as we've said, you may be able to pursue them. It just really depends on your background and circumstances, and we normally, we regularly talk to individuals and counsel them based on their backgrounds, their resumes, and so forth. Don't be discouraged. The process definitely, obviously, is anything I think anybody does. I mean, there's a bureaucratic system, and we have to work through it. But we also have to be realistic with our expectations. And as Jitesh and I have said, I mean, we give people an honest advice whether or not their cases are viable or not, because it really helps you in the long run. If I think there are many good attorneys out there, but there are some that were virtually just saying, "Oh yeah, let's try it, let's file it." And if the case doesn't have much merit, I mean, our opinion is you shouldn't be pursuing it.
Yeah.
Any other questions?
So I guess we don't have, I think there's one more.
Our contact details are right there through Tariq as well. So
Mr. Hassan, and then he can, discuss the case with you, and then, we could be involved later on. But initially, you have to send an email.
Yeah.
To Mr. Hassan, and then we go from there. We are always here to guide you. We can always talk over another Zoom call if you have a specific case to discuss. But send your resume, send your questions to Mr. Hassan, and then we'll go from there.
So thank you, Mark. Thank you, Jitesh, for your time. This was, I think, a very useful session, and I think we covered 3 great categories. There are a lot of questions over here. People keep contacting us with reference to this, and you guys clarified a lot of things for these categories. So thank you once again for your time.
Most welcome.
Welcome.
Good. I'm glad.
Thank you very much. It's been a pleasure.
Everybody. Have a good day.
Thank you. Have a nice one.
Take care.